Well, as the General Director of the Carnegie Foundation, who is the owner and the management authority of the Peace Palace, I'm very much welcome you to the Peace Palace, which in the eyes of many is not only an international courthouse, but also a temple of peace. Those were the words of Andrew Carnegie, a self-declared philanthropist who was a great believer in peace through arbitration. I have been asked to speak on this occasion in view of my varied background, which indeed includes work for several government departments. I have a legal background by training, but I'm not a specialist in the field of human rights, which will explain certain questions I would like to put forward. Generally speaking, a view from the Peace Palace should always start with the emphasis on the respect for the rule of law. In fact, the 19th century peace movement was also known as a movement of peace through law, the idea being that it is the creation of and respect for international law that will give us international peace. As I see it, the respect for the rule of law by a country means that a legal system is in place with an independent judiciary, which is not twisted by politics, and that both the public guarantees of legal protection and the accountability of leading politicians and military officials before the instances of justice are well developed. The essence is that the exercise of power is restricted by law, according to the maxim in French, le droit prime la force, and that the rights of the individuals can be validated and ascertained in a court of law. It is unfortunate that this is not the case in so many countries, also countries which have included the UN Conventions on Human Rights in their law books. As we know, the normative framework known as international human rights law is far from complete, and we are still trying to create mechanisms which reconcile state sovereignty with human rights and dignity. But for the moment, state sovereignty has the upper hand. A second remark from the Peace Palace has to be that its focus is on international arbitration and adjudication. The Palace itself is not a monitoring institute, which follows human rights developments within the borders of states. Even the most pertinent of conclusions of NGOs regarding certain countries do not lead to an official involvement of the Peace Palace, unless it would inspire a case before one of its institutions, which includes both the ICJ of Madame Sebutinde or the Permanent Court of Arbitration, which always has its cases here. For this reason, the link of human rights with international peace is clear, as stated in the preamble of the Universal Declaration. And I give you a quote. It's the first preamble, whereas the recognition of the inherent dignity and the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. These are the first words that you read if you read the Universal Declaration. Well, ladies and gentlemen, if we see that the latest World Report 2015 of Human Rights Watch announces human rights violations in 90 countries, 90 countries, we may safely assume that much of the human rights corpus is still ink on paper rather than reality. The Executive Director of Human Rights Watch, Mr. Kenneth Roth, declared human rights violations played a major role in spawning or aggravating many of today's crises. Protecting human rights and ensuring democratic accountability are the key to resolving them. The Director of Human Rights Watch denounced the policy of countries that see the issue of human rights as a luxury, which can only be addressed in good times. Still, one may observe that most of the countries where the human rights are duly respected are countries of a democratic nature with a reasonable level of development, with proper legal controls and with an open eye for the importance of the rule of law. So yes, it seems that human rights are best protected in the Western world. I take the view that corruption at all levels is often an important factor for whitewashing violations of human rights. Corruption is a phenomenon so widespread in the world that it seems that only those nations with strong and free media can escape from that form of contamination. media that will expose the wrongdoings and call for action. If corrupt leadership cannot be held accountable before the instances of justice, where do you end and how do the human rights fit in that picture? I'm tempted to say that they do not have a place, these human rights do not have a place there, or only a superficial place. If there is no law to protect the individual, his rights are up for sale. I have asked myself, if we talk about human rights, which human rights are at stake? When the European Union drafted the set of fundamental rights, which it made part of the EU treaty, first in 2000 and then in 2007, it included not only the classical rights like freedom of expression, freedom of thought, or equality before the law, but also the right to education, to health, and to a decent environment. This latter group of rights, known as economic, social, and cultural rights, is also enshrined in the Universal Declaration. My remark is here, are these last issues not more a matter of government policy than a form of human rights? Where can one see exactly the dividing line between the fundamental rights of any individual and the obligation of a state to work in the interest of its citizens? Question mark. What is the meaning of these rights if they are not specifically enforceable? Or, ladies and gentlemen, is it all the same story, basically another way to formulate policies beneficial to the people? Let me take the right to food as an example, as I have been working in that area for quite some years. The right to food is seen as a human right, protecting the right for people to feed themselves in dignity, implying that sufficient food is available, that people have the means to access it, and that it adequately meets the individual's dietary needs. The right to food protects the right of all human beings to be free from hunger, food insecurity, and malnutrition. The right to food does not imply that governments have an obligation to hand out free food to everyone who wants it, or a right to be fed. This right is derived from the International Covenant on Economic, Social and Cultural Rights, 1966, with 160 states parties, 160, later reaffirmed by the World Food Summit. But the right to food is a typically positive right in the sense that governments have to act to make it a reality. But a food policy is also a normal government task which should flow from any decent administration, e.g. not to leave its population starve or undernourished. There is, as I know of, no way to claim this right to food anywhere in the legal world. It's my view, it is in my view a very neat and civilized expression, but not a right in the traditional sense, which right implies legal remedies. You have this famous Latin maxim which is called ubi jus ubi remedium. If you have a right, you also need a remedy to protect it. Incidentally, the right to food is implicit in the Universal Declaration, but the EU did not include the right to food in its Charter on Fundamental Rights, which suggests that the right to food remains one of these lesser obligations in Europe. The EU stated that the Charter of Fundamental Rights is aimed at a peaceful future based on common values, preamble. This is an interesting formula as it, well, I should have said that it confirms the rights as they result from the constitutional traditions and international obligations common to the member states. This is an interesting formula as it refers to the constitutional traditions of the member states as the co-origin of the rights of the individual. The EU has, however, been careful not to use a language that would create rights for citizens per se. The Charter is addressed to the institutions of the EU and to the member states when they apply European law. The member states of the EU have tried, but probably in vain, to limit the impact of this Charter to the subject matter and areas within their control. Everyone who is familiar with the EU knows that certain European rules have a direct effect in relation to citizens, which means that citizens may call for a protection of their position without any intervention of the state. I see my time is limited, so I'll just see where I should go now. Yeah, I'll take this. My point so far is that the notion of human rights is more of a political and social desirability than a hard and fast rule under general international law, more a code of civil behavior than a practically enforceable obligation, with the exception of the cases where this right is protected, like in the European Convention. Therefore, it is my perception that governments would be well advised not to enlarge the notion of human rights too much and to stick to the traditional liberties of mankind, the traditional freedoms of the individual. We should also realize that these liberties are very much an invention of the modern Western world, and that there are other parts of the world where the well-being of the collectivity is placed at a higher ranking than the rights of the individual. I remember a leading religious man from the Arab world express this in public during a high-level interreligious debate in the Peace Palace. In his eyes, the interests of the individual person have a lower priority than the interests of the collectivity of people. Human rights have to be seen as rights of the population at large, not the rights of the individual. This man came from a country where women do not have the right to vote. I would like to return to the question when human rights are specific for the individual and when the so-called rights are more an expression of a desired policy. If one says that the individual has a right to live in a drugs-free environment, or that he or she has a right to health or a proper education, I see these elements more as a moral instruction to the government concerned. And as I know from an experience of 25 years as a government agent, there are always many competing claims on a specific issue, the budget not being the last of those. So, to claim an absolute right for the individual is, in my eyes, simply a bridge too far, even if this moral instruction can play a more political role in the debate. To claim that everything can be framed as a human right can also lead to a fatigue around the whole notion of human rights. Mr. Chairman, in conclusion, I would like to try to answer the key question of this seminar in the following way. International law undoubtedly comprises the notion of human rights, and in some parts of the world there are mechanisms of monitoring and protection. But they cannot yet be seen as the world's law. Human rights in their isolation are nice, but without any follow-up, they are mainly a standard for civilized behavior. It is the policies of the world's governments that will sustain, harden, and impose the human rights and give these rights the place they need. Governments should cooperate to find a platform for such issues, like in the case of the right to food, which I mentioned. Their collective efforts should make an alleged human right a reality. Otherwise, the declaration of the rights remains unrooted in the earth of the nations of the world, and not much will grow from there. Thank you very much.